This year I am starting a new award. It's called the Most Absurd Case of the Year. And it actually comes in the discrimination context. The plaintiff, Mr. Armstrong, was a 65-year-old Christian minister who was an alumni member at the James Madison University gym, so just one of those university gyms. He was a kind of a friendly, outgoing guy, so he spoke to a lot of the employees there, who were all students, of course. And he said to one particular student a couple things. And I'll quote directly from the case because I can't do as good of a job as the court can. Armstrong spoke to Calabro, that was one of the students there, about his religious beliefs, in which he claims allowed me to have a young wife even though I was an older man. He then asked her, would you be interested in communicating and getting to know each other better with the eventual possibility of marriage? Would you think about it? By the way, my grammar sucks. Yeah, Armstrong does not dispute that he brought up the subject of marriage with Calabro while she was working, and he admits that he had previously discussed romantic topics with her supervisor in the same setting. Her supervisor at the time was also a student. And then, what I think is probably the worst legal defense of all time, he argues that Calabro's claim that he offered her a farm and as many babies as she'd like was false because he made no direct proposal to her of such a situation, only a theoretical one. So he didn't say, I will buy you a farm and give you a lot of babies, but if we got married, I might buy you a farm and make you a lot of babies. What do you think happened to this guy? Right? No question. What do you think he did? He sued. He sued for religious discrimination, age discrimination, and my personal favorite, sexual harassment. He said, the guy who said that he would offer her a farm and as many babies as she'd like and wanted to marry her even though he was 45 years her senior, he was sexually harassed by being thrown out of the gym. What do you think the court did? Right? Big middle finger. Right? But here again, now this is a really extreme. Well, his attorney was himself. Yeah. Needless to say, he could not find an attorney willing to take on this particular case, right? So now this is a kind of an extreme, absurd example. I put it in to basically wake you all up, more so than because actually I think this is going to ever occur for any of us. But it is another example of a generally applicable rule in the gym, right? If you sexually harass our employees and our trainers, we're going to throw you out. I mean, this is really just application of a neutral rule, right? Irrespective of what the guy's religion is, irrespective of what his age is, irrespective of, I mean, he was the one who injected all that stuff in the case. It wasn't the, place. And I know a lot of you do meets as well in your own gyms, either as part of the training process or just because, you think it's a good thing to do, raise money for a charity, something like that, right? Well, this is where religious discrimination claims tend to show up the most, right? It's for tournaments. Because, think about it, it has to be on a certain day. Well, people might have religious obligations on that day. There may be requirements for what the competitors have to wear. There may be issues with how things are supposed to be done. There may be issues with tradition of the sport that infringe on the religious beliefs. So this is actually a very ripe area, and it's why I think it's important to go over this this year. Because I want to sort of explain what my reading of the case law is and how I think it is best to handle these issues going forward, right? So there are three cases I want to talk about that relate to this issue. One is Akiyama v. U.S. Judo. There was a judo tournament, and one of the requirements of judo is that you bow to inanimate objects before the start of the round. So there's one of them was to a portrait. In this particular case, one was to a portrait, and one was to a tatami mat. So somebody sued, so two competitors sued, and they said that their religion forbids them from bowing to inanimate objects. Right? It's sort of like a false idols type of thing. So they were not allowed to compete as a result, because that is a requirement. So what this court held is there was no evidence of religious discrimination. Religious discrimination has to be intentional, right? In this case, there was no evidence because there were legitimate reasons as to why these rules were enforced. One of them was safety. When everybody has to ballot everything first, you don't have issues of false starts. You don't have people potentially, sparring before the other person is ready. So there's a safety issue, right? Yeah, that was that. Yeah, so safety was one. Preserving the tradition of judo is another because the sport goes a very long ways back. Hundreds of years back. And also, it affected U.S. competitors' ability to compete in the Olympics because the U.S. Judo Association runs Olympic qualifying tournaments. Well, the Olympics have the requirement that you bow to inanimate objects. So it would make sense for the United States version of that to have the same rule because otherwise they could be in a situation where they qualify someone to the Olympics who can't actually compete, right? So that was another interest. So as a result, the court decided there was no discrimination here. Boyle v. Jerome Country Club. By the way, there are only 3 cases I know of that have specifically dealt with this issue, at least that are in the public record. There may be others, but that's why the case laws are kind of sparse and why we're having to go back a bit to 1995. So in Boyle, that involved a golf tournament at a country club, and it was taking place on a Sunday. A Mormon member said he couldn't play on a Sunday because his religious obligations forbade him to do so, and so he asked that he be allowed to just compete on a different day. Basically he could go on Saturday as opposed to Sunday. The court here also held no religious discrimination. Why? Well, number one, a lot of other Mormons were competing in the same tournament. That's kind of a problem, right? It doesn't look like discrimination if a lot of other people, the exact same religion, are competing. This was the only guy who had ever complained about the day. So no, they had not had any other complaints or any other requests. So the court's view was they don't want to get down the road of a heckler's veto. And then there were, the country club identified significant logistical and administrative problems with having his match on a different day because you have to have, judges, you have to have tournament directors, all of those would have to come on a different day, and it just didn't make sense to them to move the entire tournament to another day. Not to mention whose Sabbath is on Saturday, right? So you're kind of in a catch-22 there. No matter when they move, there's going to be a problem. Mm-hmm, exactly, and lots of religions have church on Sunday. Lots of people still go to tournaments. The very last one is Rothman v. U.S. Tennis Association, and this is actually the Saturday Sabbath problem. We had the Sunday Sabbath problem, now we have the Saturday Sabbath problem. There was a tennis tournament that went over an entire weekend, Friday, Saturday, Sunday, and people would have matches scheduled usually on all 3 days, sometimes 2 days. So a group of Jewish people brought suit and said that they wanted to be able to compete, but they couldn't compete on a Saturday. Now they offered 2 proposals as a way to compete. Number one is, well, you've already got matches going on Sunday and on Friday, so why don't you just move our matches to those days instead? So that was option number one. Option number 2 was, why don't you just let us forfeit the matches, and then we could stay in the tournament. The U.S. Tennis Association has a rule, which I'll go in a little more detail in a second as to why the rule exists, but they have a rule that says you can't intentionally forfeit matches. So if you forfeit a match, you're out of the tournament entirely. And so that was kind of the problem, is they wanted an exception to that rule. So here again, the court found no evidence of discrimination. Again, several reasons. Aside from there being no actual evidence that there was an intent to discriminate, they actually had intentionally moved this tournament to avoid the Rosh Hashanah holiday from earlier. So clearly there was some effort to accommodate people who were Jewish. So that was one issue. They also had Jewish people competing in the tournament, so not a big surprise there. And then as to the proposals to get around it, one of the proposals was that they just move to other days. Well, there were significant logistical problems with restructuring a tournament that way on the fly. Now, in terms of the forfeiture match, the reason why the anti-forfeiture rule exists is to basically prevent strategic forfeiture, which the Tennis Association considers a very unsportsmanlike. Basically somebody might intentionally, they might intentionally throw a match or intentionally forfeit one, so that way they can be more refreshed for the last round if they know they're already qualifying or something like that. So it's a sportsmanship issue, right? And so the court said, that's a neutral rule, it has a good justification, there's nothing wrong with enforcing it neutrally across the board, which is exactly what they did. So here are sort of my takeaways to this based on these three cases, right? Number one is ensure that any rule you have, and this is true in the gym rules context, this is true in the competition rules context, make sure it has a non-discriminatory, legitimate purpose. And especially if it's relating to safety or fair competition, those are sort of considered the gold standard, right? Because safety is important, fair competition is the reason why we even have the tournaments in the first place, right? So anytime you can link it to that, it's good. Apply the rules evenly, right? Don't make exceptions for some groups but not others. If you're going to reschedule a person's match on Saturday because they're Jewish, then don't deny the same thing to a Seventh-day Adventist, right? Otherwise, it looks and smells funny. And then last, just, and this goes back to the point Rip made, the point I talked about with the Fall case, just don't bring race, religion, or et cetera into it. Just refer solely to the purpose of the rule, right? Unfair competition and deceptive advertising. So unfair competition relates to basically consumer protection laws. You basically can't lie about products, right? And so there's a quote that I enjoy. I shared a couple years ago, and I'm going to share it again. But just to give you an idea of who this law is supposed to apply to, right? Usually we think, well, people should just be smart and be reasonable and, et cetera. But the purpose of the FTC Act was not made for the protection of experts, but for the public, that vast multitude which includes the ignorant, the unthinking, and the credulous, right? Yeah. Yes. This is from the Second Circuit, which is one of the most prestigious appeals courts in the country. So very, very highly regarded. Okay, so when we look at unfair competition, this is the standard we are looking at it through, right? This is the lens by which we're reviewing things. We're not looking at experts. We're not even looking at smart people. We're looking at people who are ignorant and unthinking and believe anything they're told, right? So those are the people we're dealing with. Now there are a couple different provisions that we're going to look that apply here. So one of them just prohibits unfair methods of competition. These are from the FTC Act. You have Section 5 and Section 12. So one of them is unfair or deceptive acts or practices, and then there's a specific prohibition against deceptive advertising, which, I mean, it probably is subsumed under Section 5, but nonetheless, they still had a separate, provision. So how do you establish that something is false? You can establish it in one of two ways, right? Number one is it just is actually false. They say A, and it's really B. My product cures cancer. Well, actually it doesn't. Something along those lines. The other is reasonable basis. Somebody makes a claim and they don't have any supporting evidence for it, right? The supplement industry gets in trouble on this one all the time, right? They put out a supplement and say it'll cure basically everything and you won't have to be on any medication whatsoever, and then this happens. Yeah, so it's I think it was Jordan has joked, what you would call alternative medicine if it worked, medicine, and sort of so the supplement industry gets in trouble a lot for the same reason. So when we are talking about health-related claims, and that's sort of our bailiwick, right? We're in the fitness industry. Supplement folks are also in the health industry. All of us are in the health industry. Whenever you have health, it is presumed to be a material representation, right? Because it's important. And when we have health-related claims, you have to have at minimum competent and reliable scientific evidence. What's competent and reliable scientific evidence? Well, thank God for the government to clarify it for us. Test analyses, research studies, or other evidence based on the expertise of professionals in the relevant area that have been conducted and evaluated in an objective manner by persons qualified to do so, who's still awake. Okay, using procedures generally accepted in the profession to yield accurate and reliable results. That's a mouthful, right? What it basically says is have reliable studies that actually show what you're trying to show and actually were subject to the scientific method, right? I mean, it's something that you're actually doing something that looks like science. Okay. Now, why is all this stuff important? We covered the background sort of as to what this is. I haven't covered any applications yet, but we've covered the background of the law. Now, why is this important? Because as we become a larger organization, one of the things we're going to rely on a lot, in fact, we do rely on a lot, are testimonials, right? Testimonials on YouTube that somebody gives us and that we post. Testimonials that people write. I know a lot of your websites, I'm sure, have customer testimonials on them. It's Frank F. I lost 40 pounds and my waist went down 6 inches with this. Insert starting strength coach here is awesome. Things along those lines. Well, it turns out that your testimonials are subject to the exact same rules as if you made the representation yourself. That is to say, you can't hide behind a testimonial, right? So, and here's here's one of the regulations that applies, right? Endorsements must reflect the honest opinions of the person, right? You can't pay them to hold an opinion and then just have them say it. It has to be something they honestly believe. You can compensate them for their time. There's nothing wrong with that, but it has to be something they believe. But more importantly, you can't convey an express or implied claim that would be deceptive if you made it directly, right? So to say it again, you cannot make a statement through a testimonial that you couldn't make yourself, is really what this says, right? Same provision here. You have to rely, if you have a testimonial, you have to rely upon adequate substantiation that suggests that the consumer is going to have a similar experience to this particular testimonial. And the FTC has said the same thing, right? Any ads that include customer testimonials should be backed by adequate substantiation that the testimonial experience is actually representative of what other people will have, right? If your product cures cancer in one person but nobody else, you don't get to put the testimonial on there that it cures cancer, right? Unless you have some medical evidence showing it does, right? But that's the point. When we make representations, it has to be something that applies across the board. Now, how does this work in application? Well, I think this is a very illustrative case. It's from the National Advertising Division. The National Advertising Division is a subset of the Better Business Bureau, and basically it's really expensive to litigate deceptive advertising claims, either with the FTC or just privately. Very expensive, a lot of discovery. You're talking, in lots of cases, hundreds of thousands of dollars to take it from start to finish. So the national advertising exists as a way to voluntarily submit disputes with abbreviated proceedings, and then the NAD will come out with a recommendation as to whether they think something's deceptive or not. The challenged company can choose to accept it or not. They aren't obligated to accept it, but the people at the NAD know these laws pretty well. And so as a result, usually what they find is what the FTC will also believe and what courts will usually find. So even though these decisions don't have the binding effect of law, they're not precedent that we can actually cite as authority, they are nonetheless very persuasive. Now, in this particular case involved a company called Princeton Nutrients, which manufactured a supplement called VitaPulse. And VitaPulse was supposed to be like a cardiovascular drug, and it consisted of pretty well-known supplements. You have 100 milligrams coenzyme Q10, 25 milligrams acetylcysteine, and then 10 milligrams of whatever the hell that is. Right, so pretty well known, right? Now, to go through this case, what I'm going to do is present the testimonials and then the support. And then, so Sully taught us all last year how we read scientific reports, how we pick them apart with methodology. I'm going to ask you all to do that because I've been talking for a while and would like a break, and so you all can go. So let's go to, okay, so here are 2 testimonials, right? Before taking VitaPulse, my blood pressure was in the upper range of pre-hypertensive and up to hypertensive, and then it went down to the lower range and out of pre-hypertensive. And all she did was start her regimen of VitaPulse every morning with a large glass of water. And then I had been on VitaPulse for a month, and my blood pressure readings seemed to be lower. Seemed to be lower. Okay. So, all right, so first question, what's the claim here? Right? Now, obviously these are testimonials, and by the way, all of these testimonials were either given directly from the customers or they were part of an online survey, but these are not paid testimonials. I mean, these are all genuine, given for free, not solicited. You know, so these are all genuine customers and their opinions. Okay, so what is the claim here? Yeah, it'll lower blood pressure, right? It's pretty obvious one. So here are the studies that they relied on. Study on 20 patients with low levels of coenzyme Q10. The study found a statistically significant decrease in blood pressure. Okay, why might this be a problem for them to rely on? Yeah, yeah, exactly. So I heard both of them, right? Number one, small sample size, it's only 20. Number two, they already had low coenzyme Q10 levels, which might be a pretty big confounding factor. Oh.
Number three, a statistically significant decrease in blood pressure is not necessarily a clinically significant decrease in blood pressure.
Mm-hmm.
So they found on average that the blood pressure went from 130 systolic to 128 systolic.
And Sully makes a good point as well, that just because it's statistically significant doesn't mean that it is, I'm just going to put it in lay people's terms, that it actually is, that it's meaningful, right? If your blood pressure goes from 130 to 128, whoopee, right? Okay, so here's the other one. A study on 26 subjects that excluded people over 75 who weighed more than 200 pounds, and they found a statistically significant decrease in blood pressure. Problems? Okay, so that's one question, right? So how many people had high blood pressure to begin with? The number's low again, right? We got 26.
And you excluded the people who tended to have the worst disease and needed it the most.
Yes, exactly, and that's the other big one, right? Who are they excluding from this? The very people they're marketing to, right? A large subset of the people they're marketing to. So as a result, the NAD held that they believed that these testimonials were unsupported and therefore deceptive claims. Okay? Here are some other testimonials. My cholesterol levels are going down, very happy with the product. I had been taking the product for about 2.5 weeks and totally flushed the Lipitor, was not going to take it any longer, and for the first time my cholesterol was lowered. I am so excited. So she got rid of her statin and everything went down because of this miracle drug. Amazing. So here's what they relied on. All right, folks, it's going to be a field day on this one. Study done on 28 subjects to measure the effect of coenzyme Q10 on muscle pain in patients taking statins. It found that the subjects experienced a small but statistically significant reduction in LDL after 3 and 6 months of supplementation. Where are the problems here? And by the way, I'm assuming everybody got that the claim is it'll lower your cholesterol. Oddly, they didn't define what they meant by lowering cholesterol, though, did they? They didn't say LDL or triglycerides or total or anything like that. But we'll put that issue aside, right? What are the problems here? Yeah, small sample size, statistical significance, right?
Length of treatment.
Yeah, length of treatments is a kind of a problem. The study wasn't even designed to deal with this issue, right? And here's the other question too. Yeah, aren't these folks on statins? What might the statins do, right, while they're on it? Maybe that small but statistically significant reduction is due to the statin, right? Versus, we look at the testimonial where she says, well, I stopped the statin. So there's a kind of a contradiction here, right? So the NAD threw this one out as well. Last one, I've been taking VitaPulse for only 2 weeks and already my energy levels have definitely improved at 90 years of age, good for her. I didn't really expect to see any benefits since nothing else I've tried has helped. She apparently does not live in Farmington Hills, Michigan. Shout out to Sully. So, okay, what's the claim here? Improved energy, right? I'm assuming everyday energy, right? Because, I mean, if you're 90 years old, you're probably not hiking the Appalachian Trail. Okay, here's support number one, what was known as the Mizuno study. It's 17 people, placebo-controlled crossover trial that used two different amounts, 100 and 300 milligrams of coenzyme Q10. They were then fatigued on a bicycle and subjected to physical performance tests, and they found that physical performance was improved. Okay, what are the problems with this? Aside from the small sample size, which is a very common theme here. Yeah. Yeah. Okay, energy and fatigue versus performance. Okay. I mean, they're measuring to the best of their ability, but I mean, but certainly valid.
The dose in the study is considerably different than the dose in the
Yeah.
supplement.
So it found that the supplementation of 300 milligrams improved physical performance, not 100 milligrams, which is in the supplement. And then the other little thing that that Princeton Nutrients omitted from their argument is that this study actually showed that 100 milligrams did not have a statistically significant increase in the ability to do physical performance later. So it actually was false, according to the study that they used, right? Okay, so I mean, now there's one other issue. Subjects are being fatigued on a bicycle and then subjected to a test later on, right? And that's supposed to be a proxy. Well, I don't think a 90-year-old woman is talking about being fatigued on a bicycle and then having energy after the fact, right? I think she's talking about getting up in the morning and going about a daily routine. So that's the other problem, is there's not really a fit here. There has to be a fit with the study that actually shows what you're trying to prove, and that wasn't really, that didn't exist here. The other one is the Nakado study, again, small sample size, so we can pass that. It found that daily 20 milligrams of whatever that thing is increased vigor in test subjects. The increased vigor was measured with self-evaluation.
RPE.
Okay, it's RPE for drugs. What? Different, yep, exactly. That's the first problem. Different dosage, right? 10 versus 20 might be a problem. Of course, the low number, and then the obvious thing that everybody laughed about. Right.
That's not to be taken seriously.
It is self-reported, right? So there is a concept in deceptive advertising called commercial puffery, right? Basically what it means is you can use superlatives to advertise your product because everybody does it. Everybody says we're the best. Everybody says you should try us. You should, that we're better than the competitors. They say, et cetera, right? And there's nothing wrong with that. As it said, as the court here says in the First Circuit, where a claim is merely exaggerated advertising, blustering, and boasting upon which no reasonable buyer would rely, we do the best auto service.
We elected a president this way.
It may be unactionable puffery. Funny you may, I say, okay, so. Now, there is an issue, though, right? Because sometimes, even if you say you're the best, it depends on the context in which you say you're the best, right? If we say we're the best training program on the market, it's puffery, right? I mean, we're just saying, hey, look, we're the best, and everybody says they're the best. But if we said we're the best at something very specific, like we are the best program at, I'll pick an example that we don't even use. We're the best program to reduce the incidence of cardiovascular disease. Well, now we just made a representation, right? I mean, that's actually something you can somewhat analyze and verify. So just because it's superlative doesn't mean it's not making a claim, but that's the important thing. So there's a case that I think illustrates this, and this is you probably recognize the product. This is Almond Breeze almond milk. The scare quotes are not in the original report, by the way. I put those in. So here, and this all related to a television advertisement that they had, and their statements were that they had the best almonds, and the best almonds make the best almond milk. And maybe Almond Breeze tastes so good because it's the only almond milk made with California Blue Diamond almonds, not almonds from China. No, he's not actually a spokesman for Almond Breeze. This particular individual is not actually one. Okay, so let me ask. I'll just throw it out. Who thinks this is making a claim? Well, who thinks it's making the claim, and who thinks it's just puffery? Right. So who actually thinks this is making a claim of some sort? These particular things, right? And who thinks it's just puffery? Yeah. Well, that's exactly what the NAD held as well, because what it said is, the competitor, which was Silk, who brought the action, they said, well, look, when you look at all these things combined, it's suggesting that Almond Breeze tastes better than its competitors because it uses the best almonds, and the best almond milk is made from the best almonds, right? So that was their statement, is when you look at it all as a whole. The NAD didn't think that was true. They said when you look at the context of the commercial and you look at how these were divided, and of course they have the picture of the smiling almond farmer who's getting the best almonds to take them over to the place. They said, look, this is just corporate pride. When you look at the commercial, nobody's going to reasonably think. They don't even say that Almond Breeze tastes better than everybody else, right? All they're saying is it tastes so good,
Maybe.
right?
Maybe. They say maybe it tastes so
Yeah.
good.
Yeah, well, maybe it tastes so good because it's the only almond milk made with blue diamond almonds, right? So in this case, the court said, look, or the NAD said, look, if you look at this thing as a whole, nobody's going to interpret this as making as quantitative claims you can verify, and that you would need to verify with things like consumer surveys or something like that, right? Okay, so when it comes to sort of the wrap up, when it comes to testimonials, basically look for try to limit your testimonials to things that will actually be representative and that we can support. And I will give a shout out. This is why the work of all of the physicians and the physical therapists we have here who are doing statistical analyses and who are collecting data and who are giving presentations every year on the benefits of strength training based on the scientific research. That's why all this stuff is so critical and why we really owe a debt of gratitude to all of you, because that allows us, because that kind of knowledge and those kinds of data allow us to make claims in our testimonials. Right? So get the data in, folks. It's important.
Hey, Brodie,
Yeah.
Does the testimonials on the forum constitute advertising?
Does the testimonials part of the forum constitute advertising? I think it does, arguably. Right? Because it's given, if nothing else, it's given its own section. Now, I will say, having gone through there, I haven't seen anything that bothers me. Right. I think everybody is pretty. The experiences are pretty much in line, right? Now if somebody wrote in one that said, because of starting strength, my cancer was cured, that could be an issue. But usually when we have.
Is it germane that we don't pay for any of those?
Well, yeah, and the fact that we don't pay for them is helpful. If we did pay for them, we'd have to disclose that, just because otherwise it would be misleading. But just like the VitaPulse, even if it's not paid, even if they just write in on their own accord, you still can't publicize that in an advertising type of manner unless there's a basis. Now, I will say, by the way, when it comes to the cancer question, I think everybody who has posted testimonials said it helped them recover because they had something to do, something to work towards. They were able to maintain body weight, which is helpful in recovery. They're not trying to claim that resistance training will actually kill the cancer cells. They're just saying it's helpful for recovery. And I don't think that's all that controversial, frankly. Yeah.
So just to be clear on the distinction here, if 20 people went around to all their friends and published on their own site, starting strength cured my cancer, that would not be an issue at all.
No, because we're not doing it.
It's only
Yeah.
posted on our.
Right. If somebody wants to go out on their own accord and write it, then power to them. They can make whatever claims about other people's products they want, but we can't make a claim by using their testimonial. All right, I'll be really quick on the CrossFit one. Just a little quote from there. Okay, so CrossFit, and I'm just going to go through this really quickly, but you know, it's there isn't a huge amount to actually go over because there's not a huge amount of nuance. So just in November 2013, a few OSU researchers published a paper in the NSCA journal regarding aerobic fitness and body comp, and the article indicated that 9 out of 54 people dropped out of the study citing overuse or injury. Now, interestingly, the part about injury was not actually in the original manuscript. The NSCA reached out to them and said, hey, why did these people drop out? And then there was an email from the person who ran this journal, the JSCR, who said, we need to include injury rates to give a full view of what the study actually showed. So it looked like the NSCA was a kind of pressuring, right? So CrossFit, because they are good at what they do, actually tracked down the 9 individuals that claim they dropped out as a result of injury while participating in CrossFit, and it turns out none of them actually said that, which is a kind of a problem. So, May 2014, CrossFit filed suit for false advertising, unfair competition, and trade libel. Right? Basically defamation, but through commercial speech is basically what they were arguing. And then, here's where things got interesting, is in September 2016, the court found as a matter of law that the article's statement regarding injury was false, right? There was no basis to claim that 9 people in the study were injured because of their participation in the CrossFit competition. Now, there were some injuries that caused people to drop out, but they were all through things outside of the competition. So one person was in a different weightlifting competition, got injured. Another person had a systemic physiological problem, etc. Okay, so that's the main lawsuit, and we're still, and the idea was that there's still a defense the NSCA could use, right? They could still say, well, look, even though it turns out that the statement is false, we still believe that it was true. So we didn't have an intent to defame. So they could have still made that argument, and that's what the court preserved. But the problem is that door got shut shortly thereafter. So a few years after the federal case began, the NSCA, apparently believing that the best defense is a good offense, decided to file suit in a state court with remarkably similar claims. And pretty much it was undisputed that all of these claims involve the same types of documents, the same types of information, so it should be reasonably consistent, right? Well, except for one problem, that the NSCA produced hundreds of documents that should have been produced in the federal case. They withheld documents. Some of them directly contradicted the deposition testimony in the federal case. For example, to give you just a primer of the kind of things this involved, one of the individuals who was actively involved in sort of the research side of things, he attended a CrossFit Level 1 certification course. And he testified in the federal case through a declaration, which is given under penalty of perjury, that he attended just based on his own interest, and that he never talked to NSCA about it. Well, guess what these documents showed, right? NSCA paid for him to go to it, and he was in constant contact with them afterwards about the various aspects of it. Basically, he was working for NSCA, right? So he perjured himself, and he actually admitted that in his deposition. He admitted, yeah, it turns out I fibbed in that federal case. Usually judges don't like to hear that, right? There's also a lot of internal emails with the NSCA that dealt with, that they were actively trying to push the injury story. There were emails that indicated that they were, very actively pursuing licensure as a way to, push out competition, including CrossFit, which they specifically named. Guys, don't put bad stuff in writing, because things like that happen. So what did the court do? It imposed sanctions of $73,000 in attorney's fees, and it gave adverse inference sanctions. Now, there were 18 different ones that it gave, but here are the highlights of them. Okay, so it established that the NSCA and CrossFit are competitors, and it actually precluded the NSCA from trying to offer evidence to the contrary. Right, and also it was established that the NSCA had a commercial motivation for making false statements in a study. I'm sure that'll be really interesting when the jury gets to read that stipulation at the very beginning of trial, right? The NSCA made false statements in a study with the intent to disparage CrossFit. This is taken as a given for purposes of trial, right? It's so one of the sanctions courts can impose is adverse inference.
Peer-reviewed study.
Yeah. So the NSCA's erratum of the study, they literally did an erratum saying, well, it turns out that, you know, they said, well, it turns out that, you know, it wasn't really 9 people that were injured, but they still suggested that 2 of the people withdrew due to injury, not mentioning that was for unrelated activities. So it was still misleading. Even when they did the erratum, they were still misleading. A loss in CrossFit's revenue was the natural and probable result of the false injury data. That's a big one, right? Causation is always a problem in these types of cases with defamation. The court just gave them the hook they needed for it. And then the NSCA was aware that the false statements in the study was being circulated to the media. It was a very deliberate, it was very deliberate on their part. And the NSCA actively supported state legislation that would regulate personal trainers. They had suggested that they really weren't, at least in the context of this case and why it's important. The court said, well, no, that you actually are, okay? This is all really, really bad for the NSCA. If they go to trial, these are going to be very problematic for them, right? So where do we go from here? Well, right now there's a lot of motion practice to try to undo the sanctions. Of course, the NSCA has asked for reconsideration. There's not a trial scheduled yet, I don't believe, because they still have to work through a lot of these other issues. But the court explicitly said that it was not ruling out the possibility of terminating sanctions if it found some other problems. Terminating sanctions means they dismiss the case, right? Or they automatically enter judgment in favor of CrossFit, and the only issue becomes CrossFit's damages. Very rarely imposed, but it might be true in this case. So, you know, where are we from here? Well, we're just, you know, we're going to have to see if terminating sanctions are imposed. I think there's a decent chance they will be if more bodies are uncovered during the course of this. And I also think this is a good lesson that sometimes, you know, when we talk about the literature, we often put it in terms of, you know, that it's sort of just they don't know what they know, but there actually are occasions where somebody is manipulating data. And that seems to be the case here. I mean, at least that's what the court seemed to think, and that's what the court seemed to hold. And so, you know, this is why we have to be especially vigilant when we see studies to look at them and not just take them for face value. And I know this organization is big on that, but I think that's true across the board and across all the industry. I think we all would benefit from a healthy degree of skepticism, even if it's a study where we agree with the result.